All right, I'm going to call the matter. This is Michael White et al. Versus Wisconsin Elections Commission et al. Case 22 CV 1008. Can I have the appearances, please?
Yes, Your Honor. Kurt Gary for the plaintiffs.
For the Defendant Wisconsin Elections Commission, Assistant Attorneys General Thomas Bellavia and Lynn Lodahl.
For intervener, Wisconsin Legislature, Misha Salem.
For interveners, Wisconsin Democratic Party of Waukesha County, Jeff Mandel and John Geis.
For intervener, Defendant League of Women Voters of Wisconsin, Attorneys Daniel Lenz of Law Forward and John Sherman for Fair Election Center.
All right, I think, well, good afternoon to all of you. I think you got in the seating chart okay, so we know where everybody is. And I think you did relate to my clerk and court reporter who's going to be making the arguments today, so I think I have that as well. I want to cover a couple preliminary things first to make sure we're all on the same page. There were a number of interveners that have moved to intervene, and I think I granted that. Most of them were unopposed. To the extent they were opposed, I granted the request under permissive, and I think we have an order then that approved all their intervention. There were a flurry of pro hoc vice orders that may have come in. I think I've signed them all. Are there any outstanding that I need to address now before somebody gets in trouble by arguing without a pro hoc vice? Hearing nothing, I think we're good there. There was a bunch of submissions already, and I've read everything. That's a lot of materials. I did read everything. Are we taking any evidence today? Was there contemplation of any evidence today?
Not on the plaintiff's part, Your Honor.
No, Your Honor.
Not on the legislature's part.
I didn't think so, but I just wanted to make sure we're set. So with that, I have read everything, but I do appreciate argument. So with that, let me hear from Mr. Burnett.
Thank you, Your Honor. I'm going to try to condense this rather complicated set of briefs into some basic points.
Hang on a second. I appreciate you standing up. Stay seated. It makes it easier because there are some microphones right there.
Got it.
And it'll help me here. I've been to 20 concerts already this year. My hearing's not the best. I want to make sure I can hear everybody. So stay seated. I appreciate you standing up, but seated is better.
Very good. I think, Your Honor, that this case really rises and falls on this court's construction of Section 6.87 of the statutes. That's well developed in the briefs, but if boiled down, it comes down to two alternatives. Alternative number one is the alternative advanced by the plaintiffs. A clerk faced with a absentee ballot that has a address or of a witness that is either incomplete or missing has two options under the statutes. The clerk can do nothing, guided by the press of business and other considerations, or the clerk can send the ballot back to the voter to rectify the problem. According to WEC and the interveners, the clerk has multiple options. One option the clerk may not do, according to WEC's guidance, is nothing. According to the guidance, the clerk must do something. The clerk may send the ballot back to the voter, or the clerk may conduct their own investigation or rely on their own experience in order to rectify the problems. So the question for the court is, what does the statute say? Well, the statute says four things. Number one, an address is required. 687 subpart 2 gives a sample of the certification that the witness must sign and swear to. And in that certification, it expressly calls for an address. There's no debate that an address is required, nor should there be any debate that WEC understands what an address is. Certainly, it understood what an address was when it developed the absentee ballot application on certification form, EL 122. It's called, and it appears in the record as document 11, page 36. That particular certification directs the witness to provide a house number, a street name or fire number, a city, state, zip code, and it gives additional instructions in the event they're rural and don't have a specific house number. So WEC understands what an address is. The third thing the statute contains in 6D is a directive that if there is an address missing on the certificate, the ballot may not be counted. And then lastly, what the statute contains in 687 subpart 9 is a directive to the clerk that if they receive an absentee ballot with an improperly completed certificate or no certificate, the clerk may return the ballot to the elector inside a sealed envelope and onward. So the statute contains four things. What is absent in the statute is any directive or any suggestion that the clerk may fix the problem on their own, that they may supplement or add information to the ballot, that they may consult other sources, or that they must respond. These are things that WEC's guidance has concocted. They've added words to the statute. Administrative agencies are confined by statutes, as are courts. Neither courts nor administrative agencies may add words to statutes that the legislature didn't incorporate. There's at the center of this case, there's one question that needs to be answered. If the legislature intended clerks to have many options, like those that WEC has suggested, why did it mention only one? Turning to the question of what the remedy is, because this is a motion for a preliminary injunction, WEC argues that even if its interpretation is wrong, this court should do nothing. And it provides a number of reasons, and I'll address a few. First of all, it says, well, laches stops the court from proceeding. Aside from the fact that we're facing a new election, which this guidance will be very important and prominent for, WEC says too much time has passed for the court to intervene. And they cite the Trump versus Biden decision, although I believe they misapply it. In Trump versus Biden, laches was applied because the former president waited until the results of the election were in and then challenged procedures that were susceptible to challenge before voting began. And the court said taking a wait-and-see approach is impermissible when it comes to elections. Here, the plaintiffs have not taken a wait-and-see approach. The legislature has informed WEC that its guidance in the form of an emergency rule, which has been discussed at length in briefing, was wrong and inappropriate, and the plaintiffs have sued before a ballot has been cast or an absentee ballot has been distributed. So laches doesn't apply for those two reasons. Laches is not a statute of repose. It is designed to stop plaintiffs who sleep on their rights from belatedly entering court, and that doesn't apply here. The second thing that is raised is standing. And that question, that objection is answered in the Teagan case, where 4 justices concluded that voters had the authority to challenge WEC-issued memorandum that inaccurately related the law. Now, there was a disagreement among the 4 justices. 3 justices relied on normal general standing principles, while Justice Hagedorn found standing in, I believe it was section 506 and section 227.40 of the statutes. But the important point is that 4 justices, a majority of the court, concluded voters have standing to challenge memorandum or counsel or guidance issued by WEC that violates the statutes. There are various arguments that an injunction is inappropriate here because the harm is not sufficiently irreparable. It changes the status quo. The equities don't counsel in favor of that. That's all addressed in briefing, and I'm not going to belabor it here other than to note that if WEC's guidance is wrong, it is not something that this court can endorse by doing nothing. If this court believes that WEC misinterprets 6.87, the obligation is to do something, and the only recourse is to issue an injunction directing WEC to change the guidance, correcting the misimpression that has been communicated to 1,850 or so municipal clerks, and to refrain from issuing other things that would disagree or contradict the court's ruling if the court accepts our interpretation of the statute. An injunction is also appropriate for a very practical reason. The current state of affairs is that clerks are poised, if they so choose, to correct information in just the way the legislature has counseled. If a ballot is missing a witness's address, all the clerk needs to do is send it back to the voter with a brief note or instruction, you need to fix this. However, if the court does nothing, if the court issues no injunction, and the guidance remains in place, there is going to be a plethora of ballots that are potentially invalid. That will only lead to further litigation. It will only lead to ballot challenges. And it will expose a number of voters to votes that may be not counted. The sensible thing to do is to compel WEC to issue guidance that actually corroborates what the legislature has determined. An injunction is also appropriate here because WEC has had every opportunity to correct the guidance it issued when the Legislative Joint Committee so instructed it that its interpretation of the law was wrong. Instead, WEC doubled down. They issued public statements that said, no, we are not wrong. They told clerks, even if the emergency rule is not valid, follow the guidance that said essentially the same thing. The Martinez versus Diller case, which is cited in the briefs, has said that that course of action exceeds the agency's authority. In Martinez, to my memory, Diller refused to follow a directive from the Joint Committee and instructed employers differently, and the Supreme Court determined that that was well beyond the agency's authority. There's also a long line of cases that indicates that voting rights are so important and voting procedures are so important, the violation is irreparable harm, and that's cited in the briefing as well. With regard to the last point, and that's that somehow or other, if the court does something, it violates the Voting Rights Act, three things are important. Number one, the Voting Rights Act, Section 10101, deals with qualifications to vote. And the voter qualifies by registering, meeting the statutory requirements. There is nothing in that act that requires a clerk to correct a mistake on a ballot. So For those reasons, we'd ask the court to grant the injunction as requested, and we would rely on our brief for further argument.
All right. I'm going to turn to Mr. Saitlin, since he's the movement as well. We'll go, I told my clerk and court reporter we're going to do an end. So we're going to go up here, then back down, and then up, and then we'll probably go back and give you a brief rebuttal. So with that, Mr. Saitlin, go ahead.
Thank you, Your Honor. I'm going to try not to duplicate too many of my friends' eloquent remarks. I'm going to focus on the legislature's core interest here, which is the institutional interest of the legislature as the body that passes the election laws in Wisconsin, and also the body that, under the Supreme Court decision in Martinez, has the statutory and constitutional authority to oversee agencies making rules. And on the first issue that my friend discussed in detail with regard to the substance of the 2016 mandate, because it is a mandate, it's not just a guidance regardless of what WAC labels it. The defense of WAC is kind of the defense of well-meaning bureaucrats who have no statutory authority, which is the statute doesn't give me that power, but it doesn't prohibit me from doing, so I can just do the good. That is not the way that agency authority works in the state of Wisconsin. Agencies like WAC are mere creatures of the legislature. We created them, and they only have the powers we gave them. Since they cannot point to anything that allows them to issue so-called guidance that mandates that clerks correct or take any steps other than mailing back or not counting absentee ballots missing an address in the certificate, the statutory issue is, with respect, easy. If WAC wants more statutory power, if the municipal election clerks want more statutory power, they got to come to the legislature. They can't just say it's not prohibited, therefore we can do it, which is their entire line of argument. But there are actually two other independent reasons why the 2016 mandate is unlawful. First, it violates the JCRAR veto, which it was upheld as constitutional in the Martinez decision unanimously by our state Supreme Court. Now, there's actually two provisions of the JCRAR approval process that are relevant here. First is 22726(2)B, which allows the JCRAR to determine that a statement of policy, the agency claims a guidance document, is actually a rule. And when the JCRAR determines that in its sole discretion, it can direct mandatorily its creature, the agency here, WEC, to promulgate that claimed guidance as an emergency rule. All of that happened here. In January of this year, the JCRAR determined that the 2016 mandate was in fact a rule. It then directed WEC to issue it as an emergency rule. WEC did so. Then there's the other half of what JCRAR can do, and it completes the picture of why that first step makes sense. And this one is 22726(2)D, which is it can veto that forced rule, forced by JCRAR's determination, after a public hearing. And then there's a couple of bases in the statute on which it can do that. That's exactly what happened here. JCRAR issued its proposed statement, WAC issued its proposed scope statement, its actual scope statement, then issued emergency rule 2209. JCRAR then convened the meeting that it has to under the statute 2 days later, reviewed the emergency rule, and vetoed it. Under the statute and under the Supreme Court decision of Martinez, that should have been the end of the ballgame. WAC, this legislature creature, it was forced to promulgate the 2016 mandate as a rule. It did so. We vetoed it. That should have been the end. But what they did is remarkable. Is they said, this whole two-step process that's laid out in statute, you made us promulgate it as an emergency rule, and then you vetoed it. All of that is irrelevant. What we can do is we can just go back to the world that was as if WAC had not been forced by JCRAR to promulgate the 2016 mandate as a rule and then veto it. If you want to strike it down, you got to go to court. What JCRAR did is irrelevant. Well, that renders the entire two-step process meaningless. If we, when we make the determination that the WAC or any agency needs to promulgate what it claims to be a guidance document as a rule, and then we veto it, that has to have some meaning. And the meaning is clear, which is that WEC or any agency can't go back to doing the same thing, can't go back to business as usual. Again, WEC or any agency is the creature of the legislature, and when the legislature follows the statutes to make clear that what the agency claims is a guidance is actually a rule, and then vetoes that rule, that's the end of the ballgame. And that's an independent, separate reason why this court should enjoin the enforcement of the 2016 mandate. And then the final reason that this court should enjoin the enforcement of the 2016 mandate is, in fact, that mandate was a rule. The Supreme Court in the Palm decision, most famously, re-articulated and applied the 5-step test for a rule. And all 5 of those steps are plainly satisfied with the 2016 mandate. Step 1 is a formal agency action. Of course it is. You see it on the WEC letterhead. 2, does it have the effect of law and it was issued by the agency? Well, of course it was. You've got the word shall, must throughout the mandate. That is under Wisconsin Supreme Court black letter law. When you got words like shall or must, that's mandatory. That's not suggestive language. That is mandatory language. Is it of general application? Yes, of course it is. It covers all municipal election clerks throughout the state. New clerks could leave, new clerks could be appointed. That's the definition of general application. My friend's suggestion that general application has to apply to literally every single person or entity in Wisconsin, I mean, that would basically make nothing a rule, because except maybe the Palm rule where we had a shutdown order for the whole state, no other regulation really applies to each individual person. You have a large class where people can exit and leave with regard to clerks. That is of general application. In fact, I would say as a footnote on those last 2 points, if they are correct that the 2016 mandate was not a rule because it literally didn't apply to all people or anything like that, then WEC couldn't have even issued the emergency rule that it did, because that also only applied to municipal clerks. And of course, then WEC couldn't issue any rules, period, applied to any municipal clerks, because that wouldn't apply to all citizens who are not themselves clerks. So it doesn't make sense. And then the final of the 5-part test is that it implements, interprets, or makes specific legislation enforced or administered. That's exactly what happened here. We have here an interpretation of the statutes, and then my friends didn't even contest that 5th element is satisfied. So for all those reasons, the 2016 mandate was always a rule, and it had to be promulgated consistent with rulemaking procedures, which it never was. So it was void ab initio from the beginning, in the same way that the executive order in Palm was void. And then finally, turning to the equities. And here I'm going to focus on the legislature's equities. As I see my friends from WEC's arguments here, their entire argument of why we don't have standing or we haven't suffered irreparable harm is entirely parasitic of their merits arguments. If Your Honor looks at pages 17 through 18 of their submission late last week in opposition to our filing, they say, well, the legislature hasn't suffered institutional harm because, in fact, we're complying with statutes. The legislature hasn't suffered institutional harm because we are, in fact, complying with the JCRAR process. Well, then we just have a duplication. If Your Honor agrees with us on any of our 3 affirmative arguments of why we should prevail on the merits, then WEC has effectively conceded that we have standing and we have irreparable harm. If Your Honor disagrees with us and thinks that they are correct on the meaning of the statutes, the meaning of the JCRA process, then we have no likelihood of success. And then if we're sorry, we wouldn't suffer harm. So they have, I think, effectively conceded that really this boils down to the merits of our 3 arguments. And then finally, on this federal issue that some of my friends have raised,
You have lots of friends.
You know,
You're a very popular guy.
They're my friends. I litigate with these folks all the time. That they've raised. There's actually 4 separate reasons why this court should not be troubled by any federal issues. First, under the well-established Chenery Doctrine, an administrative law, an agency decision cannot be upheld on a ground that the agency itself didn't rely upon. WEC did not rely upon any federal law in issuing the 2016 mandate. In fact, not even in the briefs from this court. So under the Chenery Doctrine, the whole federal law issue needs to be put aside. Second, nothing in the federal statute that they cite actually requires or even suggests that WEC can issue or should issue or must issue any sort of mandate to clerks. So whatever concerns they have under the federal statute has nothing to do with WEC. Third, if somehow the federal statute did direct WEC to do a bunch of stuff, or directed clerks to do a bunch of stuff, which it clearly doesn't, then that statute would be obviously unconstitutional under the anti-commandeering doctrine, which says that the federal government can't force states, including state agencies, to administer law. And finally, the statute itself just doesn't apply here. Here we have a privilege of voting absentee. We have certain requirements to exercise that privilege. Nothing in this statute creates the revolutionary principle that states can't have certain requirements on absentee voters that don't go to voter qualification. And for all of those reasons, I would urge Your Honor to issue the temporary injunction, or if Your Honor agrees with us that these issues are so clear, consider issuing a mandamus as a final judgment this afternoon.
Thank you. Mr. Bellotti.
Thank you, Your Honor. I don't want to repeat the content of our briefs. I think the briefing has been very thorough, so I might touch on it and respond to a couple of the points that have already been made here today, and I wanted to discuss a few things that I think came up in reply briefs that we haven't, that the Commission has not yet really spoken on. We argued, I'm starting on the probability of success on the merits and with the statutory interpretation issue first. The question is whether the election statutes prohibit clerks from adding witness address information to absentee ballot certificates. And the Commission argued, made an argument about the meaning of the terms address and missing in subsection 687 sub 6D, which is the statute that says that a ballot shall not be counted if the witness address is missing. And those terms aren't defined in the statute. But then when you get down to the question of the clerks filling in information is ambiguous as to whether they're filling in address information that is completely missing, or they're supplementing address information that's there by, for example, adding a zip code, something I think that a lot of clerks we found did in the 2020 election. They just added a zip code. I think the address was already there before the zip code was added, so those ballots were countable in any event. So to the extent that the plaintiff's entire theory of harm on which they base their standing and their request for preliminary injunctive relief is premised on the idea that some ballots are being, that due to this guidance from the Commission, some ballots are being counted that should not be counted under sub 6D. And I don't think that one can draw that conclusion at all, given the kinds of possibility that I just outlined. And in fact, Justice Hagedorn, in his concurrence in the Trump v. Biden case that's cited in the briefs in paragraphs 49, 50 of his concurrence, he found the exact same thing. And he basically went through the same logical analysis that I just set out for you. He probably did it more clearly than I've done, and concluded that there's no authority in the statutes that would allow a vote to be struck if it contains sufficient address information, but that address information had also been supplemented by the clerk writing something additional. Now, the plaintiffs have, in their reply brief, they say this is all a red herring. That's not our issue at all. We don't care about the definition of address. We don't care about the definition of missing. All we care about is that there's nothing in the statutes that says clerks can write in the witness certificate portion of the ballot. The problem there is it necessarily follows that they're saying that if the clerk does write something in there, that therefore the ballot becomes uncountable. That's the whole premise of their having standing, is that votes are being improperly counted. But if the clerk just writes in the address, it does not at all lead to the conclusion that votes are being improperly counted. So we think it's really not a red herring issue at all. And as I said, Justice Hagedorn seemed to think it was quite an important issue. As to the merits of this, the argument that since the statutes don't say anywhere explicitly that clerks can fill in deficient or missing address information, therefore the power doesn't exist because agencies only have the power they're given. I think that argument is an exaggeration. It's an overstatement. Obviously, when officials are charged with executing a statute, they always have to interpret its meaning and apply it to various factual circumstances that come before them. That's their job as the executive branch of the government. Statutes obviously cannot and do not spell out in detail every particular action that an executive branch official or employee has to perform in order to implement a statute. And part of the constitutional power of the executive branch includes the power to interpret what the statute means, and then to decide how that statute should be implemented in accordance with that interpretation. There's nothing wrong with the executive interpreting statutes. It's part of the function of the executive branch to do it for the purpose of facilitating their execution of the statute. In the case of the Elections Commission, they're charged with providing interpretive guidance to all the local election officials throughout the state. So that's what they've done here. They've taken statutes that speak in general terms, and they've confronted this problem of what to do if there is witness address information that is missing or incomplete. And they've made the rather, they were primarily concerned, I think, about making sure that there would be treatment of these kinds of ballot envelopes that was as uniform as possible throughout the state. So there's a need for clear guidance. I think that's why they spoke with the kind of directive language that they did, was to encourage that all clerks should take steps that they can take to try to correct the ballots for any voter whose ballot seems to have a facial deficiency on the envelope, so as not to get into a situation where there's selection going on and some clerks are helping voters more than others, or picking and choosing which voters to help, which is obviously not a good thing. So they've authorized they gave a whole menu of options in the guidance of things that clerks could do. One of them was that if the clerk can.
Well, that's Mr. Burnett's point, right? They gave a whole menu, whereas the statute only gave one option.
That's true.
Two options, do nothing, and then one option, here's how you do it, and that ensures the uniformity that you say is so important.
I understand that. I think we've made some of our arguments about that point in the brief as to whether that we don't think that necessarily excludes any other option. Obviously, the plaintiffs disagree. I would point out to the court that I think that all of the options that are in that guidance, except for the one that involves the clerks writing in information, actually all fall within 687 sub 9 that the plaintiffs rely on. That provision says that the clerk can return the ballot to the voter. It doesn't say anything more about how that can be interpreted, how it can be returned to the voter. So in briefing, in the rush and hustle and bustle of briefing, it is usually portrayed as if it simply means that the clerk can put the ballot back in the mail to the voter, and then the voter can make the correction and mail it back to the clerk. Obviously a very time-consuming process, especially with the slowing down of the Postal Service in contemporary times. I don't think that provision itself has to be read that way at all. In fact, it's a routine practice throughout the state for clerks can contact the voter in other ways, like by telephone, and say, do you want to come down? There's information missing from your ballot envelope. Would you like to come down and correct it? I think that's what some of those other menu options are different, are various flavors of that, ways in which the ballot can be returned to the voter, not by.
But how is the voter going to correct it at that point, other than taking it back to the witness to add
the voter could.
Are you saying the witness? No, the voter's going to add information for the witness's certification? Can they do that? Doesn't seem like they could do that.
Well, I don't. I think That's a fair question. That goes to the point of whether everything that's, whether, for instance, the way the statute is structured, 687 sub 2, it says the witness shall execute the following. Then there's some certification language. I certify these various things about the voter's a citizen, et cetera. And then there are some lines underneath. It says printed name, address, signature. Now, clearly, the witness has to sign for the certification to be valid. That's the standard meaning in Black's Law Dictionary of execute, is to validate a legal document by one's signature. The plaintiffs argue that only the witness can print their own name, and only the witness can write in their address. I don't think that necessarily follows from the structure of that statute at all, because I think that they derive that from the witness shall execute the following, and then all those things are under there. But I don't think that follows given the meaning of execute. I think execute means certify the certification language by signing. But even if the witness, I'm losing my.
Even if the witness.
Can you repeat what the?
No, I think you addressed it.
Okay, okay. Let me try to pick up my train of thought.
Sure.
So I was making the point that we don't think there's anything unusual or improper about giving guidance to fill in these kinds of practical implementation gaps in a statute. And as I was saying, I don't think that sub 9 excludes the other forms of ballot curing that are discussed in the guidance. And I don't think that the plaintiffs can, in rebuttal, they can clarify their own position, but I don't think they actually challenged anything except maybe the use of shall. But other than the use of shall in the guidance, I don't think they challenged the other forms of ballot curing, only that the clerks can't write in. So one of the things that we would ask as sort of an alternative argument is that if the court does decide to issue preliminary injunctive relief, that it craft its relief in such a way that it only invalidates the portions of the guidance that the court finds are likely to be found unlawful here and that have been challenged by the plaintiffs, primarily the clerks writing it in themselves. Because I think the guidance regarding the other options on the menu of options are all that's still valuable guidance to the clerks, and I think that it all, as I said, it all falls within the scope of sub 9, I think, so it could be upheld even within the plaintiffs framework. Then the second issue on the likelihood of success on the merits I'm going to talk about is whether the 2016 guidance is an unpromulgated rule. And the Commission's primary argument here is that it's not a rule because it does not have the force of law. That's the argument that we have primarily relied on. The plaintiffs are relying on largely on the Palm decision, in which an agency emergency order was invalidated as an unpromulgated rule. But the issue that was involved in Palm was whether the agency order was a statement of policy of general application. It was not whether the agency order had the force of law. In fact, the parties didn't dispute that order did have the force of law. So the question was whether it was sufficiently general application.
What does it mean to have the force of law? What Mr. Saitlin is saying, it says must and should and all these mandatory strictures within the 2016 memorandum. That sounds like it's law, that they're kind of required to do it. But are you saying it's something more than that? There has to be some sanction available or something else, some consequence for non-adherence?
I don't know that there's a single factor that is necessarily conclusive. But we rely primarily on Justice Hagedorn's concurring opinion in Tigan, the recent Tigan decision, where he talked about this issue at length. The three other justices who voted to invalidate the guidance that was at issue in that case did not reach the question of whether it was an unpromulgated rule because they invalidated it for substantive reasons. But Justice Hagedorn did address it and concluded that it was not an unpromulgated rule. And he talked about this mandatory language issue, even though the guidance in Tigan didn't have that mandatory language, and he acknowledged that there are cases that give weight to mandatory language and say that when an agency is speaking with mandatory language, it is more likely to be trying to speak, intending to speak with the force of law. But Justice Hagedorn really said that there was a more fundamental question that should be asked. This is in paragraph 194 of his opinion. All this discussion is around between 193 and 200 of his opinion. There's a more fundamental question that should be asked, is whether the guidance is binding and enforceable. And how has the agency actually applied or threatened to apply this guidance in practice? There's nothing in the guidance at issue in this case, other than the use of shall, that there's nothing there about enforcement. There are no threats made to clerks, and there's no history of any attempt to enforce this as if it were a binding rule. In fact, there is language at the beginning of the guidance that suggests that this is advisory guidance for you folks on this important issue, suggesting that it is not that it's not meant to be binding and enforceable. So the word shall can sometimes be advisory rather than mandatory. Typically, when it is considered to be advisory rather than mandatory, it is precisely when whatever it is that the shall is pointing to is not actually being required with consequences if you don't do it. And that's the case here. There are no consequences for clerks who actually don't follow the Commission's guidance. The Commission has never tried to impose consequences. And so we think that is why it does not have the force of law. And I would point out that if one looks at the votes in Tigan, necessarily other than Justice Hagedorn specifically said he didn't think that it was that the WEC guidance had the force of law. The other three justices would have upheld the guidance, so they obviously didn't think it was an unpromulgated rule. And so 4 held in that case that the Commission guidance was not an unpromulgated rule. And I think Justice Hagedorn's reasoning is pretty persuasive on that and applicable here, while acknowledging that there is mandatory language here that wasn't present there. The third issue on the merits is this JCRAR suspension issue. This is one that I think we very thoroughly briefed. So as I was listening to my friend Mr. Saitlin speak about this, I was tempted to repeat the arguments that are in the brief, but I don't really think it's necessary to repeat them in any detail. I guess the fundamental things I would say about this are that the legislature does not have the power to authorize a legislative committee to directly tell executive branch agencies how to interpret and implement the law. If there was if instead of this weird two-step veto process that the legislature has been arguing here, if instead of that they just did it straightforwardly, and what if the legislature just promulgated a rule that says if the Joint Committee for Review of Administrative Rules thinks that any agency policy is contrary to statute, they can direct the agency to stop implementing that policy. That would be an unconstitutional law. That's a legislative veto. It's not permissible under the separation of powers. The legislature has the power to stop an agency from implementing a policy by enacting a new law that changes the law. If it's being interpreted in a way the legislature doesn't agree with, they can create new statutory language that does not permit the interpretation. Or the agency's interpretation and implementation of the law can be challenged in the courts. And a court can declare what the law is and decide, and the court has the power to direct the agency to change its interpretation of the law following an adjudication of the issue in the courts. So you can either, the legislature can either change the law, or somebody can sue the commission and arguing that the guidance is invalid, just as the plaintiffs here have done. But what they can't do is just, JCAR can't just declare a law to be invalid, nor can they simply declare declare guidance to be invalid, nor can they simply declare guidance to be an unpromulgated rule in a legally binding way. What section 227.24.2b provides is that if JCAR makes its own determination that they think that the guidance meets the statutory definition of a rule, they can direct the agency to promulgate that guidance as an administrative rule, as an emergency rule. Now, in this case, they did that. Commission complied, and then they exercised their other power to suspend the emergency rule that they had just ordered the commission to create. You put those two things together, it's doing exactly what I just said you can't do under the separation of powers. First they say this is a rule, so you must promulgate it, and then after you promulgate it, it's contrary to statute, so it's invalid. By two steps, they've gotten where they can't ordinarily go under standard separation of powers principles. It's very peculiar, if you think about it, that the Joint Committee for Review of Administrative Rules would direct an agency to create a rule that they know to be unlawful and contrary to statutes. We're talking about the legislature. They're telling the agency to create a rule only so they can suspend that rule. I would point out that the legislature uses the term veto, and the JCRAR veto. It's not really a veto of the rule. It's a power to suspend the rule for a limited period of time during which there are requirements for submitting bills that would permanently supersede the suspended rule. And if those bills don't eventually get passed within a time frame that's set out in great detail and difficult detail in the statute, if the bills don't get passed in a timely way, then eventually the rule can go back into effect. But that's not really an issue in this case. Just that the use of the word veto is not correct. I did want to respond to the arguments that have been made about the Martinez case, because I think there's an important factual distinction that plaintiffs in the legislature have left out. What happened in Martinez is that Diller had promulgated an administrative rule. There was no question of whether the policy that was embodied in that rule was supposed to be embodied in a rule. It was, and it had been. So the question of unpromulgated rule needing to be promulgated, that wasn't the issue at all. Diller had promulgated a rule. JCRAR then acted under 227.24, and they suspended, but they did not suspend the entire rule. They suspended portions of the rule, leaving other portions in effect, thereby changing the rule's meaning, kind of like a line item veto that can change the meaning of a statute by eliminating certain parts of it. Now, if you ask me, I don't think there's anything in 227.24 that allows that, but neither the parties nor the court seemed concerned about whether that was a statutorily authorized thing for JCRAR to do, and they did it. So for our purposes, they acted lawfully, and they suspended part of the rule. So they left a modified rule in effect. That rule has the force of law, because administrative rules have the force of law. That rule continued to be binding on the entire world, including Diller, after JCRAR had modified it. Diller concluded that they thought this whole process is unconstitutional under separation of powers principles. JCRAR shouldn't have the power to suspend rules or parts of rules at all. And they then directed the parties that were subject to the ruling question to ignore JCRAR's version of the law, of the rule, and to just follow the previous unmodified Diller version of the rule. That was unlawful, and the courts rightly found it was unlawful. It was unlawful because there was a rule in effect, and the agency was saying, don't follow that rule. That's not what happened here. What happened here is that JCRAR suspended the emergency rule in its entirety. That emergency rule simply codified what was in the guidance. They suspended it in its entirety. At that point, there's no rule in effect. There's now there isn't any binding provision of law. Just before the rule existed, before the emergency rule was promulgated, the guidance existed, and everyone was functioning under the guidance. Parties that thought that guidance was unlawful, contrary to statute, could have brought an action like this one under 22740. Simply to challenge the correctness of the guidance, but it would either be, and then a court would decide whether it was or wasn't consistent with the statute. Nothing to do with all of this unpromulgated rule stuff. So I really think that that Martinez is distinguishable on that basis, and that the commission here did not at all do what Diller had done in the Martinez case. On irreparable harm, just a couple of points. The plaintiffs claim that harm through partially, they claim harm through dilution of their votes, but we believe that there's no factual record before the court sufficient to establish any likelihood of that type of harm arising. The commission's guidance actually makes unlawful, there's no evidence that the commission's guidance makes unlawful voting more likely. To the contrary, it's more probable that an envelope on which a clerk has added some witness address information contains a valid ballot than that it contains an invalid ballot, given just the fact that there are a heck of a lot more valid ballots than invalid ballots would be found in any sampling of ballots that one took. Fraudulent ballot, voter fraud is relatively rare, thankfully. It's very rare, and while it does occur and it's important, more likely than not, the ballot inside that envelope is.
You're bringing up these points about a valid ballot and a fraudulent ballot. They're just telling me to apply the law that says if its certification's not on there, or if it's missing, it can't be counted. Whether there's some evil intent behind it, or whether somebody just, for whatever reason, didn't include the address for the certification.
Well, if the address...
And if it's not on there and it's missing, the law says the ballot may not be counted. And you're drawing these presumptions, well, it should be counted because it's a valid ballot, it wasn't an attempt to defraud anybody, and therefore those should be counted. But you're making some presumptions here that are contrary to law, I think.
I'm not trying to convey to the court that I think that if the witness address is missing, that the ballot should be counted contrary to that statutory provision.
Okay.
Our position there is that it may be, I would argue that if there's partial address information that is there, then there is a question to be resolved, whether by a court or by the election inspectors in the course of a challenge process or something. There is a question there to be resolved as to whether the address is missing or not within the meaning of that statute. And that if the clerks have written in, if there's partial information there, and the clerks have supplemented it with additional information in an effort to help the ballot to be counted, that even if the court were to conclude that they're not authorized to do that, which we don't think the court should reach that conclusion, but even if the court did reach that conclusion, the fact that the clerk did that does not itself invalidate the ballot, because sub 6D doesn't say anything about that. It simply says if the address is missing. So if there was enough address information there and the clerk supplemented it, then that wouldn't invalidate the ballot. I do not mean to suggest that, now there sometimes are circumstances where often the witness will be the spouse of the voter. and they live at the same address, and they have the same name. And so there's always a sticker that's actually provided by the clerk, right, that has the name and address of the voter, and then there's the voter certification where they certify, yeah, that's me, and they sign that they followed all the rules. And then sometimes the witness will just put in their name after the witness certification and not repeat the address because it's already elsewhere on the envelope. Technically, since there's an address line there, so technically they didn't fill in that form that they had been directed to fill in that line, but I think the address information is not missing if one can determine from the information that's within the face of the ballot that this is the spouse of the person, they live at the same address, that's their address. I don't think the address is missing. I think that inspectors or a court considering that ballot envelope could say that it could be counted under 6D. So I think there are a lot of these kinds of different scenarios that make this question of counting or not counting ballots not quite as transparently obvious as it can appear at first sight. The other theory of irreparable harm that the plaintiffs and the legislature emphasize is kind of this per se irreparable harm due to simply a failure by the commission to follow the law, simply because the guidance is alleged to be contrary to statute, that if it is contrary to statute, then it's per se irreparable harm because the entire public is automatically harmed if the law is not properly interpreted and implemented. And to support this theory, they rely largely on some of the recent stay pending appeal orders that have come from the Supreme Court, particularly in the SEIU case, but also in some of the other, in some other cases. And in those cases, those were cases that involved trial court orders that facially invalidated and enjoined any enforcement of the statute. And the Supreme Court concluded that in that circumstance, where a statute is invalidated and enjoined, the will of the legislature in enacting that statute has necessarily been nullified, and that is per se irreparable harm to the public, sufficient to stay the lower court's order while the merits of the validity of the statute are fully adjudicated in the appeal. That's not what's going on here. Nobody has invalidated any statute here. The commission has no authority to invalidate a statute. The commission has interpreted a statute, and they have issued guidance that articulates their interpretation of the statute. As I said earlier, that's what the executive branch, one of the things the executive branch is supposed to do and is allowed to do. When the executive branch interprets and applies a statute, that, even if they're wrong, that doesn't nullify the statute. That's constitutional government in accordance with the separation of powers. There are methods for responding if you think that the agency's interpretation is wrong that I outlined before. Sue the agency and challenge their interpretation, and the court is empowered to direct them to change their interpretation or change the law so as to supersede the interpretation. But simply because the executive branch is interpreting the law in the way that the plaintiffs and the legislature disagree with, that does not constitute irreparable harm in anything like the sense that was an issue in that SEIU state decision where a statute had been completely invalidated so it couldn't be enforced at all. The commission is enforcing the statutes through its guidance, not saying that they can't be enforced at all. They disagree with the interpretation and how it's being enforced, and that's a separate question. But I don't think there's per se irreparable harm just because they disagree with an interpretation of the meaning of a statute. Okay, one more point, and then I will be finished. Yeah, the last point I wanted to make, just in conclusion, was a second kind of in the alternative argument related to the remedy, that any remedy the court might afford here. In addition, I asked you earlier that if you grant the preliminary injunction, that you only invalidate the witness writing in, the clerk writing on the ballot, on the envelope portion of the guidance and not the entire guidance. And I would also add that it would, if there is any preliminary declaratory relief from the court saying that clerks are not allowed to write in information, that the court also include in its declaration an indication that ballots are not automatically invalidated just because a clerk has written something on the ballot, because there's no statutory support for that. It would cause confusion and lead to some ballots being invalidated, even though there was address information on the ballot. It simply had been supplemented by the clerk. So it would be good if any declaratory relief was clear on that point to avoid that kind of potential confusion. So with that, I will stop. Thank you.
All right, thank you.
Thank you, Your Honor.
Who's going?
John Green, John Guys for the Waukesha County Democratic Party. I wanted to touch
Maybe
on-
pull the microphone a little closer. That's that thing right there.
Yeah, gotcha. Is that better?
Yeah.
Great. So I wanted to touch on a few things that have been discussed and then turn to a couple other pieces. So first, the legislature has maintained here that JCRAR's suspension of the rule also invalidated the guidance. And that's contrary to what legislative counsel said at the JCRAR hearing. We can provide the timestamp for you, but at the JCRAR July 20th, 2022 hearing, legislative counsel stated that the law following JCRAR's suspension would return to the status it was prior to the agency's promulgation of the emergency rule. And we agree with that. We think that once JCRAR suspended it, it would return to the agency's guidance. And I would submit that the legislature taking a contrary position here is a position that's recently developed for litigation based on that. Second, I wanted to just add another reason that the guidance isn't a rule. And that's Wisconsin Statute 227-0113 specifically states the term rule does not include any action or inaction that is directed to a specifically named person or a group of specifically named persons that do not constitute a general class. And in Paul, the Supreme Court clarified that that means that if it's described in general terms and new members can be added to the class, then it is a rule. Well, here it's not anything directed at a general class that people can be added to. It's directed to a very specific class. This regulation is directed to Wisconsin municipal and county clerks. And the legislature submits that people can be added to that because clerks change, people come and go. But that's a little misleading. Obviously, if someone's elected clerk, someone else leaves that position. But the number of people subject to the rule are always the same. And it is people who hold the title, guidance. People who hold the title county and municipal clerk. So based purely on one of the exceptions to a rule, this is not a rule.
Mr. Saitlin's going to say then WEC will never issue any rule because it only applies to those same municipal clerks, the actions they take.
Well,
He did say that. So they can issue no rules? Nothing they do is ever going to be a rule?
Well, I think that they could, expand beyond those individuals, and then it would be a rule. But I would also submit that we would go back to WEC's guidance. There are 5 requirements, and it at least doesn't meet 2 of them. In addition to the fact that it doesn't have the force of law. I would submit under that one. I would like to turn to, and before I go into the crux of this, I also wanted to address a question you asked about the statute providing 2 options under 6.879. That is only related, there are 2 points I would make on that. First, you only get to 6.879. It says it's the options for an improperly completed certificate. You only get there if the word improperly means that having some portion of having an incomplete address is an improperly completed certificate. The statute doesn't say that. We would submit that Justice Hagedorn in Trump versus Biden made this point too. We would submit it's not clear that having a portion of the address makes a certificate improperly completed. And second, 6.879 is subject to section 5.01 when you interpret it, as opposed to, and I will get into the legislature and the plaintiffs make a lot about how these provisions are mandatory. That's only true for 6D. The mandatory provisions here under 6.842 are sections 3 through 7 of 6.87. So yes, it is true that it is mandatory that if the address is missing, the ballot cannot be counted. But once we get outside of that, when we're talking about 6.872, saying that only the witness can execute the certification, we're talking about 6.879, an improperly completed certificate, then we're in section 5.01. And section 5.01 is very clear. It says that those provisions should be construed to give effect to the will of the electors, notwithstanding failure to fully comply with some of their provisions. And the Wisconsin Supreme Court in Roth, which is 2004 Wisconsin 6, paragraph 26, made very clear that cases construing this statute evidence a premium on giving effect to the will of the voter. So I would submit improperly completed certificate isn't really clear, and we're in a world when we're talking about that where we're meant to focus on giving effect to the will of the voter, despite perhaps not having a perfectly completed address. And I'd like to turn now to just focus a little on what plaintiffs and the legislature are asking you to do here. Because I would submit it's truly extraordinary. They seek not to just have you overturn WEC's guidance, but they ask you to offer a radical interpretation of Wisconsin law that's sure to disenfranchise voters. And they've requested that on an emergency basis in the midst of an election. It's an interpretation of law that's contrary to the unanimous WEC that passed it. It's contrary to the Wisconsin DOJ's advice to WEC in 2016, which was the genesis of that guidance. And it's contrary to the interpretation that was offered by 4 of the 7 justices of the Wisconsin Supreme Court in Trump versus Biden. Because essentially what they're asking you to do is you need to not only overturn WEC's guidance, but you also need to determine that an absentee ballot with an incomplete address cannot be counted. And the problem they raise—
Well, no one's asking me to determine what can be counted or not be counted. They're just asking me to determine whether the advice, guidance, mandate, whatever you want to call it, from WEC is valid and contrary to law.
Well,
So they're not asking that whether I count anything. No one's making a determination on any of that.
well, sure,
That's not part of any of the requested relief.
Well, Your Honor, they've submitted that the guidance is contrary to the law because it allows an incomplete address to be counted. And what I would say is that all that we have in the statute right now is a missing address cannot be counted. And there's nothing to tell clerks or to tell anyone what happens with an incomplete address. And WEC's guidance is specifically developed to fill that void and to provide uniformity. So plaintiffs in the legislature can say, yes, we just want you to overturn the guidance, say it's contrary, that's all. But in saying it's contrary, you would be saying that an incomplete address cannot be counted necessarily, first. And second, I think you would have to. And second, if you didn't, then you'd leave a gap that's contrary to the very uniformity they claim to want. Because without the guidance, 6D says if it's missing an address, it should not be counted. I don't think anyone here is actually really disputing that. But what if someone wrote their street name and not the municipality? What if someone wrote the municipality and not the city? What if they didn't write the zip code? There's nothing in the statute that speaks to that, and that's precisely, those kinds of gaps are precisely what WEC's role is to fill. And that's what they did, and they did it in a reasonable way that, again, 4 of the 7 justices of the Wisconsin Supreme Court said is reasonable, the DOJ said is reasonable, and that the unanimous WEC said is reasonable. And the reason it's reasonable, I think, is because, again, what we have is 6D. If a certificate is missing the address of a witness, the ballot may not be counted. But it doesn't say anything about incomplete address. And in fact, the words address and missing in that statute really doom the argument that it means incomplete addresses can't be counted and support the guidance. And I'd like to sort of talk about why. And I think the first place you have to look at the word address. Now, Plaintiff's counsel stated that the WEC understands what an address is based on some WEC guidance and other submissions. And I think WEC's policy on an address doesn't change what the pure language of the statute is or how they interpret the statute in that context. And in 6.87D, it says address. It doesn't say complete address. And it leaves the word undefined. Justice Hagedorn acknowledged this explicitly in Trump versus Biden when he said that, if courts completed addresses that were already sufficient under the statute, I'm not aware of any authority that would allow such votes to be struck. Right? And the reason the word address is so important there is because when the legislature wants the word address in the election code to mean specific information, it says that. And it did that, it's done that in at least 3 places of the election code. In 6.872 itself, it requires the voter to add the ward number of their town and village, or the alderman district of their city, along with their street address, city, and county. It doesn't provide those same things when it's talking about the witness address. In 6.343B2, when it's talking about a voter identification, it actually uses the term complete residential address, which would suggest that just the word address by itself doesn't mean complete residential address, but those words would be mere surplusage. And it says that including a numbered street address, if any, and the name of the municipality. And then in section 6.18, it states a former Wisconsin resident seeking a presidential absentee ballot must provide a present address, including city and state. And the reason why that's important is because the legislature didn't say any of that here. It said the word address. And in the absence of a definition, and given the precise definitions elsewhere, you have to ask what controls. And we would submit there are 3 rules of statutory interpretation that show that address in the context of the statute can't mean complete address. First, and again, Plaintiff's counsel mentioned this principle, the Wisconsin Supreme Court has emphasized that, the Wisconsin Supreme Court has emphasized that where the legislature uses similar but different terms in the statute, particularly within the same section, we presume it intended those terms to have different meanings. And that was Zinego, that's 2020 Wisconsin House 17, paragraph 64. The legislature specifically noting repeatedly within the election code, even within some of the same sections we're talking about, when it wanted address to include certain information, and that means it can be assumed it didn't specify that, and it didn't mean that regarding witness address. And second, in cases like Benson, the Wisconsin Supreme Court has emphasized that Wisconsin follows the general terms canon, which means that a word should be given its full and fair scope and not arbitrarily limited. If you look at the word address in a dictionary, it means simply a place where a person or an organization may be communicated. It doesn't include that such a place has to be defined by its street number, its municipality, or its zip code. And finally, where the word address to always mean complete address, the legislature would have no need to define the contours elsewhere in the election code, as I've already said. Or, for example, in 6.34, to use specifically the term complete residential address, because the word address would mean that. So clearly it clearly does not mean complete address in this statute. or the legislature wouldn't have to tell you otherwise where it does. And that's why the word address can't be complete address. But the second word that's really important in 6D is the word missing. And I think if you look at plaintiff's brief at page 11, it's fairly telling that plaintiffs say that the statute means ballots cannot be counted where the envelope is missing the witness's address or is incomplete. But that's one of the places in their brief where they're not quoting the statute, they're just extrapolating. And that's important because the statute doesn't say that. It says you shouldn't count envelopes with a missing address. And the plain meaning of missing is synonymous with absent, not incomplete. And so plaintiffs have talked about not adding words into the statute and things like that. And I agree. But if the statute meant a ballot should not be completed, not be counted with a missing or incomplete address, it would say that. And adding the words or incomplete into the statute violates the admonition plaintiffs' counsel pointed out from cases like Jefferson versus Dane County to not add words into a statute the legislature itself didn't see fit to employ. And I would also point out, again, that it is important that 6D is the one mandatory provision we're talking about here. Because 6.842 tells us that 6D falls within the range that should be read as mandatory and strictly construed. But that's strictly construed both such that ballots should not be counted if they violate those provisions, but also that the language has to be very tightly construed and the words have to mean what they say. And sections outside that range are treated very differently. And so plaintiffs in the legislature have talked about 6.872, where the witness has to execute the statute, and 6.879 for an improperly completed certificate, which I've already touched on. And again, those fall under 5.01, which have to be construed to give effect to the will of the electors, notwithstanding informality or failure to fully comply with some of their provisions. And so, if you take a broad view of what we're talking about here, the only provision of law we're dealing with that has to be strictly construed tells us that if the address field is left fully blank, a ballot can't be counted. And no one, I don't think anyone before you is disputing that, but the incomplete address is wholly outside that provision, and the other provisions that plaintiffs and the legislature try to bootstrap in to make an incomplete address somehow fit in there are specifically provisions that have to be read to give effect to the will of the elector. And basically, I think it's fair to say and I would submit that the Wisconsin DOJ's guidance, that the WC is called, and that the Wisconsin Supreme Court adopted basically says when reading the statutory guidance as a whole, an address need not be perfect to be valid. It merely needs to have enough information to be able to identify where the witness is. That's giving effect, and that's precisely what the reasonably discerned language of the guidance does. And given that, I would submit the reading by plaintiffs and the legislature simply can't be right. And there's one other reason before I'd like to turn to the equities, but on the merits, there's one other reason why their guidance can't be right. And beyond violating rules of interpretation, their reading would open the statute up to federal preemption. The Federal Civil Rights Act's materiality provision prohibits states from denying the franchise to eligible voters based on immaterial technical requirements. And a witness's complete address is not material to determining whether such an individual is qualified under state law to vote in the election. Under Wisconsin law, that's Article 3, Section 1 of the Wisconsin Constitution, there are three requirements to be qualified to vote in Wisconsin. You have to be a U.S. citizen, you have to be 18 or older, and you have to be a resident of the election district in the state. The complete address is not necessary to meet any of those requirements, and so federal law would prohibit the rejection of an otherwise eligible absentee ballot merely because the address is incomplete. And any other interpretation would render that section in direct conflict with federal law and preempt it. And I would note that actually 6.842 and 5.01 and the interplay between them seem to consider and account for federal law by strictly limiting the provisions of the absentee voting code that are construed as mandatory. there's a reason why section 6.842 is written to have very limited and specific provisions of the absentee code that are mandatory, whereas in all other instances, section 5.01 tells you that minor errors have to be tolerated to give effect to the will of the voter. And that's because it keeps Wisconsin, in part, it's at least because to me it seems, it keeps Wisconsin law in compliance with the materiality provision. And on this point and on the federal point, I would submit that plaintiffs in the legislature's arguments, at least in their briefing, here they've offered some different arguments. I would say in their briefing that the principal argument against this is that a witness address is required under state law, so it's material to determining the qualifications. But if that were the standard, that would swallow the entire rule, right? I mean, the Third Circuit recently said in McGlory versus Cohen that the materiality provision was created to ensure qualified voters were not disenfranchised by meaningless requirements that prevented eligible voters from casting their ballots, but had nothing to do with determining one's qualifications to vote. And I would submit if you rejected ballots based on a lack of a complete witness address, you would be falling directly into what federal law prohibits. And so, on the merits, in considering all of those factors, plaintiffs in the legislature have offered you a problematic interpretation of the statute that raises federal issues, while DOJ's reasonable interpretation of the statute has been relied on by the WEC for the last 6 years, complies with how you're supposed to interpret Wisconsin statutes and with federal law. And WEC unanimously adopted this interpretation based on the DOJ telling it it was reasonable before the 7 justices of the Wisconsin Supreme Court agreed. It's reasonable, it's in line with how you should read statutes under 5.01 and 6.84, and it keeps Wisconsin law from running afoul of federal law. And we would submit that that dooms plaintiffs and the legislature's likelihood of success on the merits. But likelihood of success on the merits is only one requirement for the extraordinary relief of a temporary injunction. And so now I'd like to turn to equity very briefly. I think it's really important to take a step back here and look at where we are in the election cycle. We're in the midst of the election. The Wisconsin Supreme Court has explained that the general election and its primary share a critical nexus, and that the primary is part of the election. And so plaintiffs in the legislature really are asking you to make a fundamental change to the rules while the election is happening.
Did that happen in Tigan? The ballot boxes, didn't that happen in Tigan? For the primary had the ballot boxes, and then the other one, the actual general election didn't.
Was it Tigan? I have to check it. Yeah.
Tigan was in July, which was before the August primary.
Go ahead.
Your Honor, the difference in Tigan was that the rules were changed, the drop boxes were closed, but any voter attempting to return a ballot to the drop box would know that. They would get there, they couldn't use it, and there would be instructions on the drop box telling them how to return their ballot. Here, by contrast, voters who have submitted a ballot, first of all, voters can request absentee ballots for both the primary and the general election at the same time. So a voter who has requested absentee ballots for both the primary and the general, who then returned their primary ballot, followed up on my vote to make sure it was counted, could do the exact same thing when their general election ballot comes in the mail, and that ballot might not be counted because of the change in the rules. It's a completely different situation because the voter doesn't have the same kind of doesn't automatically have the kind of notice they had when they would have gone to a drop box and it would be, and the drop box was closed.
And I would submit that that is a huge voter confusion problem, and it would lead to a host of administrative issues for clerks and for organizations like the Waukesha County Democratic Party who try to help people navigate these rules to vote. And there's a reason that timing is important. I will acknowledge, I'm an election voter. Sometimes in elections, that kind of timing is unavoidable, but it was entirely avoidable here. WEC's guidance has been on the books since 2016, and this very issue was discussed at length by the Supreme Court in Trump versus Biden in 2020. Plaintiffs in the legislature have had 6 years to either challenge this issue in court or, in to address it through legislation. And they've had 2 years since the ruling in Trump highlighted this issue in detail. So it's simply too late to come now and ask for a temporary injunction to implement this change while an election is happening. And if you look at their briefs and what they've said here today, neither one of them really offers a meaningful excuse for that delay. Plaintiffs have submitted that they're on time because, unlike in Trump, they did not wait until after the election. And in their briefing, they pointed out they filed their temporary injunction a week before the primary. But I think that argument is insufficient for at least 3 reasons. First, they filed the temporary injunction 3 weeks after initiating this case, and they took no action to get a ruling before the primary election, and in fact agreed to a briefing schedule that would make sure their motion was heard after the primary. And second, to a point my co-counsel has raised, in Wisconsin, absentee ballots are mailed out 6 weeks before the election. So even when they first filed, ballots had already gone out to all of the voters. And third, I would just submit that waiting till the eve of an election when you've had 6 years just isn't appropriate where the equities are concerned, regardless of that timing. So just because this challenge came before the election doesn't make it true. And I would point your honor to the Wisconsin Supreme Court's case in Hawkins versus Wisconsin Elections Commission, which is 2020 Wisconsin 75, rejecting an attempt to put candidates on the ballot between a primary and a general because the relief would cause voter confusion and undue damage. And plaintiff's relief here, again, would do just that. And the reason Hawkins is important is because the Wisconsin Supreme Court made the determination and issued the ruling that that was too late on